Thank you very much. For only a half hour before the breakout session is not a whole lot of time to discuss the very many different aspects of the financial side and the legal side of planning for a progressive deteriorating disease. So hopefully you can save your questions for the breakout session. What makes this topic especially difficult is that although all of you may think that you're similarly situated dealing with a family member who has frontotemporal dementia or any other type of dementia, that you're not all similarly situated, because if you're planning for your spouse, that's different than if you're planning for your parent or you're planning for your sibling. So those relationships sometimes make a big difference. Also, what makes a big difference is your assets or your level of income. Sometimes if you have a long-term care insurance policy, that could make the planning very difficult or much different as well. So really what the best advice I can give to you is that I will raise general topics of concern that you should be aware of, but it is always best to seek out individualized advice that deals specifically with your own situation so it can be analyzed and you can get to the information that you need. Often when someone comes to me and says, well, that's a little bit different than what I've been told by my neighbor down the street because they have the same thing and they were told this. And I say, well, I can't really tell you what the story is with your neighbor, but I can very certainly tell you the situation with yourself, because little things make a big difference. And it's very helpful when you seek out this advice to get an individual who is knowledgeable about this area. Generally, the category that lawyers who practice in this area are known as are elder law attorneys, which can be different than just a trust and estates lawyer. We get a lot of referrals from individuals who are lawyers who do trust and estates, but because of the fact that this is so specialized and it changes so often, that you really need to get advice from someone who deals with it regularly. So that being said, there are topics that we generally deal with. One of the most important ones is surrogate decision making. How are you going to make decisions for your family members when they become unable to make decisions themselves? I know it's late in the day and saving the financial and legal stuff is enough to put you to sleep, even if it was at 9 o'clock in the morning, so I'll try to make sure that I keep it interesting. So that's one important topic. The next important topic is, how are you going to pay for the care that your family members need? And that one continuously changes, because it may start off being just care at an adult center or possibly at home or in an assisted living facility and so forth. And that's a real big topic. And the reason why it also is difficult is that it changes often. The most common program that pays for long-term care is medical assistance or Medicaid. That is a joint program that is run by both the federal government and the state in which you live. And although each state has to conform to the minimum aspects of the federal law, there's lots of variability. And whenever there's a tax bill, because the entitlements play such a large role in the budget, then they tighten up or they change or they tinker. And then you have something that goes on like this summer with Act 42 with the Pennsylvania legislature, when they're passing their pay raises. They also tinkered with Medicaid substantially, and they made it a lot more difficult in certain aspects. So that makes it a difficult topic as well. Another difficult aspect is that it involves all kinds of different taxes, both death taxes and gift taxes and income taxes, and if you transfer a house, possibly transfer realty tax, and you name it, it's involved, and that in itself can be very difficult. And finally, you have the whole traditional estate planning topic of passing on your wealth from the family member, the adult, to their children or to a spouse. And you do not want to do Medicaid planning that may particularly satisfy a goal for Medicaid planning if it completely disrupts or goes against the plan for estate planning that the individual had initially established. So those are the broad topics that have to be addressed, and I'll touch upon each of them probably pretty on a very basis that is not as detailed as I would like, and as I said, we'll go into the breakout session. I can answer more questions then. So how are you going to pay for health care when your family member becomes unable to make decisions? It's without question that the disease, if it runs its course, your family member will become unable to make decisions. And on the film that you heard, they talked about a power of attorney and guardianship, living wills. Those are all types of ways in which you make decisions. I break it down into two categories. The first is voluntary arrangements, and the second is involuntary arrangements, because, and I'll address the second one first, involuntary arrangements, because if you do not plan at all, or if you plan inadequately, then there is no question that you're going to have to run into the situation of an involuntary arrangement, and there's really only one in Pennsylvania, and that's called guardianship. And guardianship, as with all of these arrangements, has some good aspects to it, but a lot of them have bad aspects, and guardianship in particular is something to be avoided if you can. And what is a guardianship? A guardianship is a court-imposed decision-making procedure that when the person has not been planned for some other alternative voluntary way, that you hire a lawyer such as myself to prepare papers, to go into court, to file them in court, to then get what's called a citation, to personally serve it upon the alleged incapacitated person, to then have a hearing in court, to have a doctor come and testify why your family member is unable to make decisions themselves. And there, when you have a guardianship, the judge will decide whether the person is completely incapacitated or only partially incapacitated, and if they're completely or partially incapacitated, whether they need a guardian over their person or whether they need a guardian over their estate or both. And one thing that you try to do is not go in too soon to get a guardianship, because with the nature of this disease, that if, for example, your family member is having trouble making financial decisions but is still capable of understanding a medical treatment, if you go in and you only go for a guardian over the estate, then maybe a year later, when the person's disease has progressed, you have to go in for a guardian of the person. And as you can see, that when it involves all these procedures and you involve lawyers, that it involves cost. And a guardianship can be quite costly. It can run anywhere from $2,000 up to $5,000. If you happen to own real estate, then you no longer have the right to make decisions about whether it will be sold or not. You have to ask permission of a judge as to whether or not it should be sold, and if so, for how much. So once again, that can be another layer of cost. So I try to avoid guardianships. What I try to do is try to keep the person at home safely and try to bring in services for as best as you can, and hopefully that as the disease progresses, maybe the individual will become a little bit more cooperative and will go along with the game plan. If in fact the person is no longer safe at home and they refuse to say that I will go to an assisted living facility or something like that, then you may have no choice but to go for guardianship. And in that situation, going for guardianship is very good because it is involuntary, meaning that once you have the hearing, once you have the adjudication that the person is incapacitated, then that person no longer has the right to make any decisions in the area that the judge has declared them to be incapacitated. So that means they may not be able to handle their funds at all, they may not be able to make any medical decisions, they probably can't vote, they probably can't get divorced or get married or things like that. So it is a significant deprivation of one's rights that you try to only deal with when there's no other choice. So Another reason to avoid guardianship is that if you've ever been involved with one, it's very socially stigmatizing to your family member. Usually they have to be present in court to, unless their presence would be harmed, their well-being would be harmed by being present, and they have to listen to the doctor testify. And although they may forget about it after a little while, when they're sitting there and when they hear this, they clearly understand that what is going on, and it can be very disheartening. Another reason to avoid guardianship is that it is inflexible. Although you may be caring for your family member, if your sibling decides that you're not doing it the way that they would like to do it, then if they file the guardianship, then it's the judge who decides who should be guardian of the person and who should be guardian of the estate. The judge also decides, for example, if you're going to sell the real estate, who should for what amount should it be sold. They also decide things such as if you're spending money, how much can be spent on your family member's care. So when we talk about some of the ways of health care financing, if you are planning on trying to undertake some of that planning, if you have had your family member adjudicated incapacitated, then you have to ask permission from the judge, and the judge generally will not allow you to do that. So for all those reasons, I try to avoid guardianship. So what's the most common voluntary arrangement that someone enters into? That is a power of attorney arrangement. Sometimes you hear durable power of attorney, but really in Pennsylvania, all powers of attorney are presumed to be durable unless, in fact, it's written in a way that it is just for a limited period of time. Basically, the power of attorney is executed by the principal, who then designates an agent to make whatever decisions are authorized within the document. There's been a new format since 2000 that says there is a big notice in the front that says you're giving someone broad authority to make decisions on your behalf, and they can do so without knowledge to you, and if they do make these decisions, they always have to act in your best interest, and so forth. And then the agent has to sign an acknowledgement that says that they've read the power of attorney, that they'll follow all the rules. If they handle their principal's assets, they'll keep it separate from their own, and they'll generally follow the law. This is everyone, if you take nothing else away from this lecture, you should take away the importance of having a power of attorney. Sometimes your family member would say, I'm not going to sign one of those things, and sometimes they never do. But if they don't sign it today, maybe 2 months from now, they may be willing to sign it if they recognize that they're starting to have problems making decisions. You can't wait till they can't sign at all, because they still have to have a level of capacity to make decisions and have a level of understanding that they know what's going on. So if you've waited till they don't even know who you are, or they can't even sign their name, then you may not be able to get a power of attorney. Power of attorney is good, but it's not perfect. Some people think, okay, I have the power of attorney. It says that I have the right to make placement decisions. So as soon as my mom signs that, I'm going to say, okay, Mom, you're going to the assisted living facility. She can look at me and say, I don't think so, because it is a voluntary arrangement. So if, in fact, she's refusing to follow what you're saying, then basically she is revoking your authority to make that decision. And simply because they signed the power of attorney does not mean that they themselves cannot make the same decisions. It just means that you as well, the agent, is authorized to also make decisions. So some people say to me, well, I'm concerned because my mom keeps on going to the bank and keeps on withdrawing like $100 a day, and then I say, where's the money? And she has no idea, and I want to get this power of attorney to prevent that. Well, getting a power of attorney is not going to prevent that. So that's a drawback. You can have the power of attorney designate one person as the decision maker, two people that they must act together, or they can act separately. If you have a power of attorney designating someone, you should clearly have a successor, because if you have a husband and a wife and you designate the spouse as the decision maker and the spouse dies, and then you don't have a mechanism. So having a good power of attorney is very important. You can probably go to a legal stationery store and even buy one. It may not be as well drafted as one with an attorney. It's not terribly expensive, $100, maybe $200, very important. Those are the two major ways in which you make decisions. Okay, let's talk about how you pay for health care. You pay for health care depending upon the level of care that you need, and there are 3 levels of care: skilled, intermediate, and custodial. Skilled care is generally not a problem. The individual has usually Medicare or a major medical. In the case of this type of dementia, they're a bit younger, they're not qualified for Medicare. You have to be over the age of 65, so you have a long-term, you have a major medical policy that will pay for that care in the hospital. That's a direct, if you fall and you break a hip, you go into the hospital, you need rehab, you have a stroke, something like that. Having the major medical or having Medicare is important and will pay for that type of care. Having just a Medicare policy is generally not sufficient because Medicare doesn't pay for a lot of things. So you generally should have a supplemental health insurance policy to go along with your Medicare. If you're disabled and then you also get Medicare 2 years later after your disabling event. Nowadays they have a managed Medicare policy where you're not technically enrolled in Medicare but by an insurance company, and those policies are a little bit less expensive. But generally not a problem with skilled care. At the other range of care is what's called custodial care, and sometimes they have different names for that: personal care, assisted living. And that's the kind of care that a person needs when they're initially suffering from the early stages of the dementia. And you don't need anyone who's medically trained, but you do need someone who will assist with the activities of daily living, helping them get dressed, helping them shower, toileting, feeding, things like that. If you only need that level of care, then there's really no government program to pay for that. You either pay for that out of your own pocket, private pay, or if you happen to be lucky enough to have a long-term care policy that pays for that kind of care, then depending upon the policy that you have, depends upon what it'll pay for. Generally, people who have this type of dementia are younger. They haven't thought about having a long-term care policy. Trying to get a long-term care insurance policy with a diagnosis of this FTD is not the same as getting a auto insurance with a bad driving record. You become uninsurable. So if your family member already has the diagnosis, long-term care insurance is not an option. In between skilled care and custodial care is what's called intermediate care. Most individuals who have FTD or dementia of the Alzheimer's type will need intermediate care. Usually it's never a battle about whether you need intermediate care. The question is whether or not you qualify it for financially. In order to qualify for Medicaid, medical assistance, you must need intermediate care. You must be receiving that care at a Medicaid certified facility. Your income must be less than the cost of care, and you must not have available resources. So I'll just touch upon them a little bit more clearly. Basically, the right level of care is usually not a battle. Having it at a Medicaid certified facility is usually not a problem either, because most nursing home facilities are Medicaid certified. There are some that are not. Whether they are or they're not doesn't mean they're good or they're bad, just means that they'll accept medical assistance for payment. Nowadays you have assisted living facilities such as a Sunrise that has a specialized dementia unit. That is still an assisted living facility. They are still not qualified for medical assistance, and if you spend all your money, you spend down all your money on that kind of facility and you run out, then Sunrise will say, I'm sorry, you have to leave. So if you're going to be in that kind of unit, it's better to be in a unit of a nursing home that is Medicaid certified. The third is that the income, a person's income must be less than the cost of care, and that's pretty easy as well. Nursing homes cost about $7,000 to $8,000 a month. Not too many people have that kind of income, so that's basically is not too hard. And the last thing is that you must not have available resources, and that is a term of art because it includes some things and it doesn't include other things. In this situation, when you talk about available resources, this is where there's a big difference between planning for a husband and a wife versus planning for a parent. Because if you have a husband and a wife, and the wife has dementia, the husband is entitled to a certain amount of assets himself, as well as a certain amount of income. Whereas with the individual who's in the nursing home, if you just have a parent, then you don't have as many exemptions. So let's first talk about what an individual in a nursing home can own. And the answer is not too much. They're allowed to have, if their income is below $1,700 a month approximately, they can spend down to $8,000, so they can keep cash of $8,000. If their income is above $1,700, then they can have to spend down further to $2,400. That is their cash needs that they can keep. They're also entitled to an irrevocable burial reserve account, meaning that if you're going to be spending money on nursing home charges and you spend all that you have to, and then the person passes, then if you have to pay for a funeral, you have to come up with additional money to do so. And that basically is a waste of that money. So if in fact someone is going into a nursing facility, one of the first things you should do is create an irrevocable burial reserve account. You can do it one of two ways. One way you can do it is by basically going directly to a funeral home, pre-arrange, pick out whatever merchandise you want, and then they'll tell you this is how much it costs, and you pay that money. The other way to do that is you go to a bank and you open up a separate account that is segregated from the rest of your assets. It is irrevocable, meaning that once you put the money into it, as well as once you give the money to the funeral home, you cannot get it back. But by the same token, the government does not require you to basically spend that money, so that is exempt. The last major asset that is exempt is the first $1,000 of cash surrender value of a whole life insurance policy. So if your family member has a policy that pays $2,000 at death and the value of the cash value is under $1,000, you can keep that as well. Once a person qualifies for medical assistance, then their check goes to the nursing home and they can only keep $40 a month. So that's what the individual in the nursing home can keep. The community spouse is entitled to some extra assets. One other thing, but let me go back. A person in a nursing home is also entitled to keep their principal residence if there's an intention to return home, meaning that if they say, hey, if I ever get better, I'd want to go home, then the state will not make you sell your home. By the same token, they don't give you any money to maintain the home, but they don't make you sell it. But it doesn't help you very much, because if you qualify for medical assistance and then the state begins to pay for your care, upon the person's death, there is something called an estate recovery program that they will put a lien against the home. So if you basically happen to maintain the home the whole time, you can just, and the person was in the nursing home for a couple of years, the house is only worth $50,000, $75,000, you might as well just turn the keys right over to the state, because they'll get all the money. Okay. The community spouse is in a little bit better position. A community spouse is entitled to retain the home, their principal residence, and the state will never make you sell the home to pay for that care. So it can be worth $100,000, it could be worth $300,000. In this situation, you're allowed to keep the home. Of course, if it's jointly titled, and if the well spouse predeceases the incapacitated spouse, and the house goes back to the incapacitated spouse, then you're in the same situation and you've kind of wasted that. So generally speaking, what a state law, elder law attorneys suggest is that the community spouse transfer the house from both names into their name alone, so that if they predecease the institutionalized spouse, and if they've changed their will, because the wills generally say if I die first, everything to my spouse, if my spouse dies first, everything to me, then if you haven't changed your will, it goes back to the spouse. So changing the house and then basically changing your will is important. That brings up the point of having a good durable power of attorney, because if you think you can change a deed to a home just because you're the spouse, you're in for a little bit of a surprise. The government doesn't care. If you're not authorized under a power of attorney to make that kind of transfer, then in fact you're out of luck. Okay, so the house is a major asset. one thing that's important is that a lot of times with FTD, because it hits the individual when they're younger, they may have a mortgage on the home. So it's important to basically, if you're placing your family member into a facility, then the assets that can be kept, which I'll talk about in a second, is taken right then. And if you take some of the assets, you can pay off the mortgage, and in essence, money that would have to be spent on the nursing home gets paid into into an exempt asset. Another major asset, and I'm sorry I'm going quick, but I don't have much time and there's a lot to cover. Another major asset is a retirement account, a qualified retirement account of the community spouse, meaning if you have a pension, a 401k, an IRA for the community spouse, the state disregards that. If that is the account or asset that the institutionalized spouse has, then that is countable. So sometimes if you have a big pension, then you basically are okay there. So you're also allowed to have the Barrel Reserve account for the community spouse. You're allowed to have an automobile. Personality is generally exempt. Those are the things that are exempt. Okay. In addition, once you pull out the exempt assets, the community spouse is entitled to a certain amount of the available resources. Generally, it is half up to a maximum. They're entitled to a minimum amount, about $20,000. So if a person has a house and $20,000, they can keep everything. But if they have $200,000, they cap it as of 2005 at $95,100. Beginning in 2006, it goes up to $99,000. So really, you can spend half, you can retain half, but then you have to spend half as well. The community spouse is entitled to keep all of the income that he or she earns. So if their income is $4,000 a month, they get to keep it all. If their income happens to be only $500 a month, the community spouse is entitled to keep some of the income of the institutionalized spouse's income. The maximum amount that you can have is $1,604. So in my example, if I'm getting $604, then I can keep $1,000 of my wife's assets. In addition, that figure $1,604 can be raised up to about $2,300 if in fact you have shelter costs, either for a mortgage, real estate taxes, utilities, things like that, that basically make your income requirements higher. Okay. There used to be something called the Hurley election that is still out there that basically allows someone, if they need more assets, more income, to keep additional assets, but they kind of just changed that with the law that makes it very difficult to do, so I won't even get into that. Finally, transfers. If you have money on day one and someone goes into a nursing home on day two, and then suppose you give away a lot of the money on day three, and suppose you gave away all of the money so that on day four you apply for medical assistance, the government will say, hey, you just had this money and you gave it away, so you're not eligible. So giving money away creates a period of ineligibility. The maximum period of ineligibility is 3 years unless you create a trust. Sometimes we create trusts because a spouse can keep more assets otherwise than if they don't. If you transfer assets into a trust, then the period of ineligibility could be 5 years. However, the period of ineligibility can be less than that period of time depending upon how much is given away. It's all based upon what is called the average cost of care of the nursing home as set by the state. This year it's $6,062.39. So that if in fact you give away $6,000, the period of ineligibility is 1 month. If you give away $60,000, the period could be 10 months, and it can be longer. The break point is about $225,000. One of the things that are being discussed in Washington right now is changing when the look-back period begins. It used to be that as soon as you made the gift, then basically that's when the period of ineligibility begins. They are thinking about changing the period of ineligibility to begin when the person goes into the nursing home, so that if you gave money away 3 years ago and it created a period of ineligibility of 1 year, then that 1 year doesn't begin to run until the person goes into the nursing home. So things things continue to change, and who knows where it all wind up. We used to have something called the waiver program that allowed people to provide, if you're sick enough to have care in the nursing home, to basically get that care at home. It doesn't provide 24 hours a day, usually about 6 to 8, but they had very favorable rules about what assets are looked at, meaning that they didn't look at the community spouse's assets. So you could move all the assets from one spouse's name to the other, and then you then could qualify for care under the waiver program. They've changed that. It's the exact same rules now under the waiver program as for institutional care. So as you can see, I've only really ran through this very quickly, but there's lots of different issues that are important when you come to dealing with healthcare financing for your family member with FTD, and it's important to get personalized advice to sort through all of them. Thank you.